Number 761, Carl Calvin Westover, Petitioner versus the United States. Mr. Fawcett.
Mr. Chief Justice. Yes. May it please the Court. Before I begin my argument, I should like to call the Court's attention to a disparity in the record of this case, as disclosed by the respective briefs. Inasmuch as I had no opportunity to discover this disparity until I received the Solicitor General's brief this weekend after I arrived in Washington, this is the first opportunity I have had to do so. And I do so lest the Court think that simply because I took this case under court appointment, I have somehow been negligent either in carrying out my obligation to my appointed client or in presenting to this Court, to the best of my abilities, the true and full facts as I knew them. The discrepancy occurs in that while my knowledge of the case here and below has been predicated upon the official record, certified first to the Court of Appeals and then here, the Solicitor General's brief makes liberal use of additional materials not a part of the official record on appeal, never made available to me until this past Saturday from the kindness of your clerk. This is the material which the Solicitor General's brief refers to as, quote, supplementary papers in Note 1, page 1 of his brief, consisting of certain pretrial administrative papers and the exhibits in the trial court, both those exhibits which were, and in one particular significant particular one which was not, received into evidence. All of these materials, as I learned on Saturday, were forwarded to this court in late January of this year. I am as much surprised by some of the information in them as I am by their sudden appearance at this time. I am green and unknowledgeable as to the ways of the court, and I don't know whether the court should be considering them. I do know, however, that in view of their 11th hour, 59th minute appearance, I am inevitably caught somewhat by surprise. I will try to the best of my ability to integrate the new material into my argument here. Necessarily, it has not been integrated into my brief. I would simply ask that the court keep that in mind. Excuse me. Because of the shortness of time allotted for argument, as well as presumably the court's most particular interest, I will limit my oral argument to the confession issues involved in this case. In this case, there are two. One, whether for lack of counsel's actual presence during a police custody interrogation, petitioner's two confessions were properly admitted into evidence under Escobedo versus Illinois. Two, because this is a federal case, whether without regard for Escobedo, petitioner's confessions were improperly admitted as a matter of federal criminal law under the standards of McNabb versus United States and, more specifically, Anderson versus United States. The factual circumstances surrounding the confessions may be briefly stated. On the evening of March 20, 1963, at approximately 9:45, petitioner Carl Calvin Westover was arrested as he entered his parked car on a side street in Kansas City, Missouri. The arrest was made by two officers of the Kansas City Police. The chief purpose for the arrest was the suspicion that the petitioner was involved in two local Kansas City store holdups. Both petitioner and his car were searched. A certain packet of money was recovered, and his car was impounded. He was taken to the Kansas City police station, was at that point placed in a lineup, identified as to one of the local charges. Thereafter, the police booked him, quote, for investigation. At that point, he had denied all criminal activity. The following morning, however, the Kansas City police, apparently, according to hearsay testimony at his trial, did obtain a confession on one of the local robberies shortly before noon. At approximately 11:45 in the morning, the Kansas City Police declared themselves through with the petitioner, and the FBI office in Kansas City was at that point permitted to interrogate him. In something less than 3 hours, they returned from the interrogation room with 2 narrative form statements or confessions to the 2 federal robberies here concerned. The confession, although in the handwriting of one of the interrogators, was signed by the petitioner. Each of the confessions recited that Westover had been advised that he need not make a statement, that any statement he made might be used against him, and that he had the right to consult an attorney, quote unquote. Each also recited that, quote, no threats or promises, unquote, had been made to induce his statement. Each also recited that the statements were, quote, voluntary. By the time these confessions were secured, Westover had been in custody for approximately 17 hours. He had not been taken for arraignment, or loosely arraignment, more properly preliminary hearing, before either a Kansas City magistrate or a U.S. commissioner. The following day, petitioner made certain changes in his statements, still in custody. The federal involvement in Westover's detention had included, besides the confessions themselves, the following. 1, a specific telephone request prior to the booking, quote, for investigative check from the FBI that, quote, the subject be held for them also for questioning. At this point, it would seem appropriate for me to clear up the principal discrepancy between my prior understanding of the case and with what the Solicitor General's supplementary papers now do disclose. It was my understanding that the felony warrant from Sacramento, California, to which the arresting officer referred and to which his arrest report referred, was a warrant on these 2 federal robberies. The government, however, states, and one of their supplemental papers indeed seems to show, that the felony warrant, Sacramento, California, was a state, not a federal warrant. My brief is, of course, in error, therefore, in arguing that the clear federal interest was shown at the time of arrest. However, those same papers, which the Solicitor General has found, do clearly show that at least by the time of the booking, if not the arrest, the FBI was itself very interested in the petitioner for its own purposes. They show that the booking was, in fact, at least as much for the FBI as for the local matters or the California felony warrant. As the arrest report, which is prosecution's Exhibit 12 for identification, shows, Westover was not booked on any specific charge. As in Haynes versus Washington, it was a, quote, small book, hold for investigation. It then reads, well, specifically it said investigation check dash robbery. It then goes on to list the 2 matters which were to be checked, then recites as follows. Prior to booking the subject, information was received from FBI agent Leon Dobb that Westover was wanted by the FBI for questioning, and also that Sacramento, California holds a felony warrant for the subject, which will be forwarded to this department. In concluding, it recites, Carl Calvin Westover was booked for investigation to be held for the number 1 and number 2 station detective units, this department, and for the FBI. Curiously, it appears to me in reading the Solicitor General's brief that there is quite a conscious attempt to convey that the only outside interest, the only FBI interest at the time of the arrest or booking was the felony warrant, California. This may not be conscious. I think it certainly reads that way. The facts, however, show quite the contrary, that there was an independent federal request for detention for its own questioning. These supplemental papers also show that, at least at the time of the booking, the federal authorities, one, had a pretty fair idea that Petitioner was connected with the two Sacramento federal robberies, enough to want to question him, and two, that they had, by their request, actively contributed, if not to the arrest, to the booking and to Westover's subsequent detention for investigation. The other matters of federal involvement are well enough documented in my brief to warrant the passing reference here. The joint federal-state examination of the recovered currency, the joint federal-state seizure of the top coat, the use of the state-seized gun in procuring the federal confessions, and finally, the transmittal of the state photographs or mugshots to Sacramento, California, for use in the case. On the basis of these facts, we submit that under both Escobedo and/or Anderson versus United States, the confessions were illegally admitted. Notwithstanding these two different questions in this case, I cannot urge too strongly that both questions, uncounseled interrogation and protracted detention, are, in my mind, both fundamentally vital to a determination of the first issue, the Escobedo question. Thus, it would seem to me a big mistake for this court to follow the lead offered by the Solicitor General and by the two governmental amicus briefs filed here, which would seek to segregate these two items into two separate cellophane packages. One, police interrogation, and as a second element, quite apart, the period of lengthy detention. As 4 of the 5 cases right now before this court indicate, protracted detention for interrogation appears a routine police behavior. It is precisely because of this detention that, as it seems to me, the need for a safeguard such as presence of counsel has had to be evolved by this court. As in Escobedo, it was to protect the incarcerated suspect from unwittingly or unadvisedly relinquishing his constitutional privilege against self-incrimination. The evil sought to be corrected by an Escobedo-type philosophy is not the street corner confession, not the soul-bearing spontaneous confession of guilt, not the, quote, picture streaked with confusion and alarm, as the government suggests on page 23 of its brief, nor indeed does it have to be, and this perhaps does not here have to be decided, it does not seem to be, the brief question and answer period during what the government calls the completion of administrative formalities. What Escobedo does do, it seems to me, is to strike at precisely the very same evil which, for federal law, the McNabb-Anderson exclusionary rule sought to strike at over 20 years ago, the secret detention for purposes of eliciting a confession. The second difficulty I find with the Solicitor General's approach is more serious, more crippling. The Department of Justice would have this court turn back the clock as though Escobedo and its precursors, such as Spano, White, and Messiah, did not exist. Thus, the government states, as Mr. Earle has earlier alluded to, Escobedo was, in fact, nothing more than one more case of a coerced confession, determined under strictly traditional totality of the circumstances views. In this light, the government expresses some amazement that the present case is before your court. Says the government, repeatedly and at great length, there is, quote, no showing on this record that petitioner's confessions were the product of, quote, coercion or, quote, overbearing on the part of the interrogators. viewed as a matter of the, quote, totality of the circumstances. Of course, we never argued that there was. What we did argue in our brief, do argue now, is that the protracted detention combined with the police interrogation is itself inherently and unavoidably coercive. In that sense, then, Mr. Justice Black, as opposed to the two petitioners who have already appeared before you, we do, yes, claim the confession was coerced. We believe that Escobedo went farther than coerced confessions. We believe also it was not simply a question of the wrong to be righted, but a step in providing a remedy for that wrong. The fundamental philosophy of Escobedo seems to be the right against self-incrimination. The fundamental force of Escobedo seems to be the understanding, the realization that the right to counsel is necessary to remedy that situation. Under traditional views, we concede this particular case would presumably not have merited nor received review by this court. We submit, however, that under Escobedo, the court is trying to establish something less ephemeral, less open to case-by-case doubt than the special circumstances type rule of Abetz versus Brady. Finally, on this point, I would suggest that the Solicitor General's entire approach to the problem in terms of police necessity versus individual rights is topsy-turvy backwards. As already discussed, some of his alleged police needs, quote unquote, are entirely wide of the mark. They themselves straw men or possibly red herrings. Escobedo would not in any case interfere. Others are particularly irrelevant to the terms of this particular and not atypical case. Thus, his reference to, one, the unwitnessed crime, or the police officer forced to act, quote, in the exigencies of the moment without opportunity for detached reflection. Quite obviously, these are most thoroughly inapplicable here. I submit they are hobgoblins conjured up in order to frighten this court back from what it has already held. It has already held it is not simply interested in coerced confessions under traditional views. In any event, however, the approach is backwards. The court has affirmed in loud tones that in weighing police need and individual right, the balance has been struck in favor of the latter. Thus, if the Solicitor General's approach of a case-by-case evaluation of the totality of the circumstances is correct and should be adopted, with exceptions thereafter to be carved out, we submit the rule, the starting place, should be the individual's constitutional rights versus self-incrimination as protected by the right to counsel. With the police interference with those rights, the exceptions, being the matters which should be allowed in exceptional cases where, on a totality of the circumstances, a need in fact is shown to exist. Certainly there was no such need here. As the prosecuting attorney himself stated, the confessions were simply the frosting on the cake. As the Solicitor General's brief admits, the other evidence was overwhelming. There simply was no police need at all. And I submit that Mr. Siegel's credentials notwithstanding, we would find that in many cases, when confessions were used, there would be no need at all. On the point of Anderson versus United States, I think I would have to. It's a difficult point, and I think it certainly should be briefed and argued before it was decided by the court. It's not presented here.
The confession is necessary to the case. It may not be because the confession produced other evidence.
That's right. I understand that. Yes, it may. It may. There are no figures on any of it. There are no figures as to how much need there is for a confession to secure its fruits when perhaps independent police work would have found the same evidence about as quickly. Sir? Yes. Yes, it's just as right. On the Anderson point, I would just like to make a very brief comment. Even conceding that, as I now discover, the federal authorities had no part in the original arrest, they clearly had a large and a thoroughly well-documented part in the subsequent detention or investigation. We submit the many pertinent facts and factors surrounding Petitioner's arrest, detention, overwhelmingly bring the case within Anderson. They also put the case squarely outside United States versus Coppola, 365 U.S. 762. There it was found the federal authorities had, quote, in no way caused or contributed to Coppola's detention, unquote. Exhibit 12 for identification precludes such a finding here. It was also found in Coppola that the interrogation by the FBI, quote, did not contribute to any delay in arraignment, unquote, since he was initially interrogated by the federal authorities in the midnight hours. Here, when the interrogation began at 11:45 in the morning, certainly no such finding can be made. I submit that if the court sanctions what occurred in this case simply because the detention was nominally that of the state, although not for any specific state charge, it will effectively have taken all teeth from the McNabb exclusionary rule. It will encourage states to adopt broader and broader small book statutes. It will openly invite federal authorities to find themselves sanctuary, forbidden to them directly, in requesting to state authorities that the subject be held for them also, or questioning. In our case, as a matter of federal law, if not as a matter of constitutional law, the confession should have been excluded, the conviction should be overturned.
Mr. Solicitor General.
May it please the court, I will have to check on when the page proofs were mailed to Mr. Fawcett, and I will be able to report that after lunch. I will have that checked. I think in the first place we have to get a few things cleared up on the factual basis of this case. There is not one word in this record at any place that there was any cooperation at all between the state and the FBI, other than one, that they did notify him they wanted to talk to Westover, and on 11:45 the following morning they told him they'd like to talk to him, and they didn't until 12. This 17 hours is also very interesting. He was arrested at 9:45, carried to the Kansas City Police Headquarters after questioning on the street, and searched. And at some time thereafter, he was put in a lineup and identified. And at 11:45, he was booked. And Petitioner himself says booked into the jail. We are unable to find in the record whether he was booked at the police headquarters or the jail. It's kind of confused. But I have checked, and while it does not appear in the record, the jail is directly across the street from the police headquarters. But this interrogation for 17 hours is not in the record. The record shows he was questioned for a portion of the time between 9:45 and 11:45 at night. He was questioned sometime the next morning, but the only pinpoint on that is that 11:45 he was seen talking to a police sergeant in the open area of the police headquarters.
It's 11:45 the next day, the next morning?
11:45 the next day, he was seen talking to a detective sergeant, I think a Klein or something like that. It appears it was in the open area. The other thing is that what is in the record is that at no time was any federal officer present while the state was questioning. That's positive testimony. There's also positive testimony that there were no state officers present when they questioned him. And when you bear in mind that between 12 and either 2 or 2:30, they had gotten 2 full statements from him, and the time it took to question him and to write it out in longhand, it would appear to me that he must have started talking very soon after 12 o'clock. It just stands to
noon of the day of the arrest?
No, sir.
When you say 12 o'clock, what do you mean?
12 o'clock the next day. He was arrested the night before. The FBI asked for him at 11:45. At 12, they gave them a private room, and the federal questioning started at 12 noon on the day after his night arrest at 9:45. There is also evidence, and this evidence is from the defense counsel in calling FBI agents as his witnesses, despite the judge saying it looks as though you got somebody with a uniform of the other team on, but he still called them. And they testified positively that this man was in perfect condition. He seemed to have complete control of his faculties. And number one, there's nothing in this record that he ever asked to call anybody at any time under any circumstances. The record also shows that he was obviously from California with California license plates, living in a hotel in Kansas City, and so far as the record shows, he didn't have any friends, relatives, or anybody else. He did not take the stand himself. He sought to build his case on government witnesses, particularly FBI agents, and he didn't make the grade. It's also apparent that he made a choice, and that is in the record, where the court said in sentencing him, I think it was on 70. Well, anyhow, I can get the page. In sentencing, the court says, you know and realize that had you been tried under the laws of the state of California for this same robbery, you could have gotten life. And he said, yes, sir. And I think that he made a choice. He constantly denied the crime to the states. And when the FBI talked to him, he made his 2 statements.
We'll recess now. Mr. Solicitor General, you may continue your argument.
Mr. Chief Justice, and may it please the court, I checked during the luncheon recess. Page proofs were mailed by air mail on Wednesday. And if they didn't reach, it's not the fault of the Department of Justice, it would be the fault of the Post Office Department. I'm sorry if you didn't get them. When I concluded before lunch, I was at the point where I wanted to make it clear that while there's nothing in the record to show what happened the night before, there's also nothing in the record to show that Westover was at any time warned by the state. There's nothing in the record one way or the other. The statutes and the rules of Missouri do apply that a man must be brought to the stage of arraignment within 20 hours after arrest. That brings me to the point that I think is the crux of this case, is that the Mallory rule and the Anderson case and a couple of cases so relied upon by Petitioner just do not bear any factual basis in this record. I don't believe there is, at this stage, of anything wrong with the state and the federal government in the prosecutorial stage, having a statement where one asks the other, if you find so-and-so, I want to talk to him. There's no question that when he was picked up the night before, it was, as the petitioner admits, primarily for the 2 robberies in Kansas City, specifically a finance company and a bakery. Much is made of the fact that the money that was seized on Westover, $600 and some, was seized by the state police and was examined jointly by the state police and the FBI. It is true that the state and the FBI jointly took down the serial numbers. One read it off and the other marked it down for the use of both to see which place the serial money would fit into. And the record shows, at least as to the federal charges, in the banks that were robbed, they had these packs of money with marked bills in, which they stick into the tellers' cages for this express purpose in case they are robbed. But that's nothing illegal about the cooperation in that stage. Secondly, as I mentioned, there were no federal officers present during state interrogation. That is in the record, positively. Secondly, that the state police deny that they made any inducement to Westover. That if you talk to the federal or anything, they never mentioned it to him. Then it's repeatedly said by each of the witnesses that there was no deal of any kind between the police and the FBI. And this evidence is brought out by the defendant. It's clear that at the time the FBI examined Westover, he was a state prisoner and not a federal prisoner. On page 79 of the record, there is testimony that Westover, when the FBI began to question him, he was mentally alert and appeared to know exactly what he was doing. No evidence that he had been held up late at night or kept awake or anything. There was no federal warrant outstanding at the time of his arrest, at the time of his questioning by the FBI, and the FBI agent says positively at the time they questioned him, they had none of the details concerning the Sacramento robbery. Not only was he advised of his rights by witness of the evidence of the 2 statements he made, but the FBI agents testified from the witness stand that he was fully advised of his rights. And the statement is that I advised him that he didn't have to make a statement, that any statement he made could be used against him in a court of law, and that he had the right to see an attorney before he made the statements. And the final point is everything I have said is uncontradicted.
At what stage was that statement made, General?
During the questioning between 12 and 2 or 2:30. There were 3 agents there.
During the questioning by the FBI?
Yes, and the statement says that he was told in front before he made the statement. But the test, sir?
Before he made any statement at all.
That's what the statement says, but this says, where it doesn't say exactly when, it says, were the statements he made free, was he advised of his rights? And after he was told that he went ahead and made the statement, so it appears from page 82 that it was before the statements were made.
He didn't ask for counsel.
There's nothing in the record to show that he ever asked for counsel.
Is this what's been referred to as the standard FBI warning?
Yes, sir, this is practically it, and it's always given, and at least so far as the Department of Justice is concerned, has witnessed this unaltered practice of the FBI. We think that this is the practical way to do it.
Mr. Solicitor General, what if, upon giving such a warning, the person being interrogated says, I want to call counsel?
This statement says that if he wants to see an attorney, he can do it before he talks. That's what this warning
And
says.
if he says, I don't know anyone, don't know a lawyer, and I can't afford one anyway, what happens then? But I still want to talk to one.
If he says, I still want to talk one, then it would be my position that the most the agent would have to say is, we do not have a lawyer, we have no means of furnishing you a lawyer.
Well, but can the agent go, will the agent then go on and
I
interrogate?
think the agent would then say, in view of the fact that we can't give you a lawyer, we can't pay for a lawyer for you, do you want to talk? And he is then, I think, in a position of saying, if I don't get a lawyer, I don't talk, and that's the end.
In other words, you'd say, you'd read a waiver into it.
I don't think it's necessary, Mr. Justice Clark. I don't want to be accused of dealing semantics, but at this stage, I'm not too sure he has a right which he needs to waive.
Well, if the FBI said, we can't give you a lawyer, we can't furnish you a lawyer, and we don't know anybody to call, well, then they asked him to go ahead and make a statement or infer it to him. Under those circumstances, if you wish to go ahead, you may. Well, that would be, would you say that would be a waiver?
It would be the waiver of his right to remain silent. It would be a waiver of his right to remain silent, I would think so.
Well, they just said, well, under those circumstances, we won't take any statement.
We will not take a statement?
We won't interrogate you.
Well, I think it's up to the agent at that stage. That's a possibility, but I think the more likely possibility would be the agent will say, since I can't give you a lawyer and I don't think you have a right for us to furnish you a lawyer, I ask you again after repeating this, do you want to talk? And then he has the choice to make.
Well, what if he says no? Just says, no, I don't want to talk without a lawyer.
That's
then
it.
Is the interrogation over?
That's what I would think.
Well, is it? Or, and you know what the practice is? Do they say, oh, come on now, and go on asking him questions and presenting...
Well, I would say that once the man makes it clear that he does not want to talk, or he will only talk on certain terms, and those terms are not met, I think that the authority at that stage should stop questioning.
Well, do they? No.
I don't know, sir. I
You don't
imagine it
know
would
whether-
vary, but with the FBI, I would be reasonably certain they'd stop.
You don't know whether they
honestly think
get a lawyer for him later. Suppose he's an indigent or he's busted.
Well, if he's an indigent, I just don't know of any facilities in existence to get a lawyer. I don't think the
Prior to arraignment or something.
prior to arraignment, I'm sure that speaking for the federal government, there's no provision I know of to hire a lawyer.
Of course, if the counsel point doesn't need to get into it at all, if the fellow knows enough to say, well, I just don't want to talk without a lawyer here, he knows enough to say, I just don't want to talk.
That's if he
And,
understands it, Mr. Justice White. If he understands this, which I submit an average person can understand, then I say the only purpose of a lawyer at this stage would be to advise him of what this statement means. Well, if he knows, he doesn't need it.
Well, but what if they ask him the question? They say they give him the warning, and he says, I don't know a lawyer, I can't afford one, and the agent says, well, we have no lawyers to furnish you. Now, do you want to talk or not? And he says, well, and the agent says, well, you don't have to, but if you want to, we want to hear what you got to say. And he then doesn't say, no, I don't want to talk. He says, well, what do you want to know?
Well, then I think he's talking voluntarily. And he's not being, in any stretch of the imagination, either being forced or tricked.
Yes, but he's talking without a lawyer.
Well, I don't think that well,
how does he know enough? How does he know enough to make that decision of whether to talk or not?
I think it depends on the individual.
Do you
If you
think whether a
remember,
lawyer is present there or not is relevant to what?
I think the lawyer being present is relative to this point. And if I may go right straight to the Escobedo case on that, where the man wants to see his wife, Haynes against Washington, or wants to see his lawyer, Escobedo, and the investigating authorities say The only way you will see that person is for me to allow you to see him. I've got the key in my hand to open the door, and I'm not going to open it unless you talk.
Well, that's different. That's a different case than if they just say, well, we don't have a lawyer, and
That's right.
you don't need to talk, but do you or don't you want to talk without your lawyer? And he says, well, what do you want to know?
If the man, number one, if the man says the one way he has a lawyer, I want to call my lawyer, et cetera, then I say the normal procedure would be you'd have to wait until he calls his lawyer and his lawyer talks to him. When he says, I don't have a lawyer, I'm broke, but I would appreciate if you'd get me a lawyer, you said, well, we don't have a lawyer, we have no means of getting a lawyer for you.
Which is true.
Which is true. And so far as I know of no place, unless it's some legal aid society voluntarily puts lawyers in there. And that's not true in any place I know of.
As soon as he says, I want a lawyer, why hasn't he automatically said, I don't want to talk without one, and therefore the interrogation should cease?
I think we would have to just about say that.
Yeah.
There's nothing wrong with him saying no.
Yeah.
In this case, there's nothing that he's ever... so far as we know, as soon as the door shut, he started talking.
Do you think that the situation that Justice White's asked you about invokes any principles in the Griffin in Illinois and those that succeeded it? As I understand it, you say that, of course, a person who had a lawyer, had money, or who had money to get a lawyer, and could call him, could get one immediately. But this man has no lawyer and has no money to get one. And the only reason he doesn't have a lawyer today is for that reason. Does that raise any principle of what an indigent is entitled to? He's certainly not getting treated like the man ordinarily who has money to get a lawyer.
But he's not being denied anything. He's not being denied anything. The state is not affirmatively denying him anything. The state just is not furnishing him something.
That was the trouble in some of these other cases.
Yes,
in
but
fact, the state didn't have any provision to supply him a lawyer, but we said that if other people have lawyers and have entitled to have them, entitled to have lawyers represent them at that point. The man's too poor to get one.
Well, I think all of those cases, Mr. Justice Black, is where you have a right, and I don't think you have a right to a
But I
counsel.
understood you to say if he had had money, he would have a right to have his lawyer there at that moment.
He would have a right to consult his lawyer.
All right. He would have a right to, but the man who's too poor to get one has no right to do it. He has no chance to do it.
I think
That's the situation we had in Griffin and the cases that succeeded it, isn't it?
Yes, but Griffin was a different point.
I know it was a different point, but it was
Because
based on the fact that in the trial procedure...
we can't equalize the whole thing.
That's right.
I just don't believe we can.
What power, in your judgment, from what provision of the Constitution does the government's power to detain him and question, to detain him and question, what provision of the Constitution grants that power?
I've been unable to find one that grants it as such. It's inherent in the investigatory process preceding the prosecutorial process. And I don't think it's ever been questioned.
Well, it is with me.
I know it is, sir.
How long do you
doing my level best.
How long do you say they can hold him?
I think that the question of holding him, I'm not unaware of the other questions were asked. I think he can be held for a time to at least check out what he was arrested for. And that time would be a very short time. I am thoroughly in complete agreement with arraigning the man or giving him the judicial process as soon as is possible.
But it's one thing to hold him, perhaps for the purpose of checking out what they know about him. It's another thing.
Yes, sir.
It's another thing to interrogate him during all that time they're holding him to check out, isn't it?
Well, providing the interrogation is on the checking out point. Because, for example, a man has an alibi and the alibi is out of town or something like that. if the alibi was right there, you could check it out in 15 minutes. If he's out of town, it would take 2 hours or so. I mean, I don't think there's any short line we can put down. My point is that when the questions are made and the answers are made, I think the mistake is in reading the mind of the questioner. I think you should read the mind of the person who is making the statement. And if he is making the statement on the theory that he is obliged to make it, and not even as far as has to make it, then I think that's overreaching.
My trouble with that is this. I have no doubt that what government has a right to make inquiries about crime. No doubt about it.
Yes.
The question is, do they have a right to detain people as though they are under arrest for the purpose of questioning and questioning when they're there alone and detained or imprisoned during that period of time?
Well, I think that comes to the point that we have to decide on what kind of a crime we're investigating, what are the problems, and I'm not balancing, Mr. Justice Black, but there's sir?
That's not forbidden, but a lot of them
Oh, I don't think I will tread. But if I may, just to give you 2 cases we mentioned in our brief, the question of the well-trained criminal lawyer, if by any chance anyone of them might commit a crime, and he's investigated, he wouldn't need a lawyer. But that could be considered as going to the end. But there's a case pending here right now on certiorari in the Second Circuit, U.S. against Cone, where a man is caught with a huge case of marijuana on the chair beside where he's sitting, and a few marijuana cigarettes in his pocket. And the agents take him outside, the narcotics agents, in broad daylight in the middle of Manhattan, and in walking the 1 block down from the studio where they picked him up to the car, they don't warn him, they question him, and he tells the whole story. But it was all a part of the arrest. I don't see any overreaching there to hold such a confession out. Then you have the confession where the man's been there, and I think the important point of the Chief Justice's story, when you're holding him for this questioning him, you certainly can't hold him incommunicado. That is absolutely forbidden. If he wants to talk to his family, he shall be permitted to do it. If he wants to talk to his lawyer, he should be permitted to do it. But the only advice a lawyer can give him is what this statement means. The lawyer can't prevent him from being fingerprinted. The lawyer can't prevent him from being mugged. The lawyer can't prevent him from being put in a lineup. The only thing the lawyer can do would be to tell him,
Not yet,
this means.
Mr. General.
Well, Mr. Justice White, I would hope not as long as this court sits, end of quote. I would hope. But I think the real point is that the major difference we have is the denial of the right to see your own lawyer. And I respectfully cannot get too close to this ability to hire a lawyer. You couldn't staff every precinct with a legal staff of lawyers. It can't be done. And once the rule is made that a man is entitled to a lawyer once he reaches the precinct, you must, by force of power in Alabama, insist that it be an effective counsel.
Mr. Solicitor General, apart from the decisions of this court looking to the Constitution and to the matter of theory, what is the basis for your statement that if a man has counsel and wants to consult counsel, he should be allowed to do so? What's the constitutional basis?
I don't think that, I don't say that he has a constitutional right to see his counsel. I said to deny him the right to see his counsel or his wife makes the statements that he makes conditional upon him seeing them.
Well, perhaps I am not following you, but are you saying that there is or is not a constitutional inhibition? Let me put it this way. Are you saying that there is or is not a constitutional inhibition against using a confession which is given after denial of an arrested person's request to see his lawyer?
I would say yes, sir, with one exception. If it can be construed that the person confessing gets the feeling that unless I talk, I won't see my lawyer.
Well,
I think that's inherent.
Well, let me pass that.
All right.
What is the basis of that? What is the basis of that constitutional right?
It's the Fifth Amendment, which, as in those circumstances, puts upon the man making the statement an unreasonable restraint in urging him to talk in order to gain something.
You think it defeats his constitutional privilege?
It remains out.
His constitutional right to remain silent?
Yes, sir. Yes, sir.
Now, how do you distinguish that from a situation in which a man says, I want to see a lawyer. I haven't got one, but I want a lawyer. Then that's denied to him, let's say, and let's say the interrogators say, sorry, if you haven't got a lawyer, we're not going to produce one for you. And then the arrested person confesses, and the confession is offered at his trial in evidence. Now, in that case, does the Constitution prohibit the receipt and evidence of the confession or not?
No, sir, because...
Now, why not? What's the difference in constitutional terms?
The difference, as I see it, Mr. Justice Fortas, is that in the second case, there is no possible urging that the man can get that if I make this statement, you'll then let me talk to a lawyer.
Oh, well, why not? Because in one case, the only difference between the two cases
is that there's a lawyer
that in
there.
the first case, the fellow says, I know a lawyer. And in the second case, he says, I don't know a lawyer, but I want to talk to him. But I want to talk to a lawyer.
I go back to I see not too much difference with my position on Escobedo and Haynes. The reason, Haynes had a wife.
I understand that.
But if he hadn't had a wife...
I haven't yet heard anybody urge that the state's got to go out and find him a wife.
Well, I didn't want to go that far. But I think it is that there is something available to you. And if you don't incriminate yourself, you won't get that something that you would normally do.
But, General, in the case where a man has a lawyer...
Yes, sir.
He's a gangster, let's say, somebody in organized crime. They're the fellows that generally, as I understand it, have lawyers, not the little fellows.
Before the crime, sometimes.
Now, in the case of an organized crime fellow,
yes, sir,
he's got a lawyer. Your position is that if he's not allowed to consult with that lawyer before he makes his incriminating statement, that then the incriminating statement should not be received in evidence because in that case you say there's psychological pressure on him and the statement is not voluntary and he's being compelled to, in effect, to make statements against himself.
No, sir.
The only difference between that case and the case where that I put to you is that in the second case he's doesn't have a lawyer whom he's retained.
Well, I don't say automatically that confession is out of the second one, because if he's had enough, if the record shows that he's had this lawyer represent him in the last 6 court appearances, I think if I was a judge, I could say he knew his rights.
Well, General, may I ask you what you would do with this case? And it happened in the district here just a few years ago when, 3 or 4 years ago, when they were arguing the Mallory decision over the Capitol. There was a robbery one night in a restaurant, and the robber not only took the money away from the woman cashier, but he beat her up in a brutal fashion. And she gave a description to the police. And the police went out into a certain area of the city and gathered up 90, not 9, but 90 people who might answer that description. Got them out of bed, threw them into jail at night, and didn't process them by morning. A lot of them couldn't go to work because they were in jail for suspicion of robbery. Now, would you say that those who had lawyers there could get out and not be interrogated, and those of the 90 that were too poor would be entitled? They could be interrogated by the police until they got a confession if they happened to have done it. It happened that not one of these 90 was a guilty party. They found him later, but that was the way they did it. 90 people they threw in jail.
Well, I've always been opposed to dragnet arrests of any kind, but if I may say so, to really put that in proper focus, anybody that had a lawyer would have gotten a writ and got his man out.
Well,
but you wouldn't have to get a lawyer to get a writ to get the other ones out. That's the way the law is now situated.
Well, I don't quite understand you. They were arrested in the middle of the night, and if they could get on the phone, as you say, and get their lawyer, and the lawyer said, "Well, don't talk to him. I don't want you to talk to him," and they would follow that advice, then the police could do nothing with them. But the rest of them, who had no lawyer and perhaps were poor and couldn't, at least at that time, get a lawyer, you think that the police would have the right to retain them and question them ad lib?
As the law now stands, I would say that the only redress they have would be that they were the subject of this dragnet arrest and their rights had been denied by the dragnet arrest, and that anything came as a result of it would go out. Now, that's what I think the court should do in such a case.
Well, then all of them, whether they had a lawyer or not, in those circumstances, would go out.
Would go out when they, I mean, you wouldn't be able to use those statements in court, in my position. I don't think so, because the arrest itself was invalid, and any incarceration then was bad. But on the cases we're working on the theory that the arrest was a valid arrest.
Yeah. You don't suggest that we overrule Escobedo, do you?
No, sir. I think that Escobedo can very well fit into this case under the Fifth Amendment point. But I don't want to in any way give support to any theory that we believe that Escobedo requires that a lawyer be appointed to an indigent in the police precinct or at the arrest.
Yes.
Supposedly, if you use accusatory stage as the point, and a policeman's coming down the street and crash goes in a window, and he rushes up to where the crash is, and there's a rock inside of the window, and the man with his hand on some jewelry. Well, he's in a rather accusatory position. Well, you wouldn't need a lawyer for him at that stage. I mean, this accusatory thing is, I think, what gets us in trouble. It's where the man's mind is changed, not the police's.
Well, General, you wouldn't ask us to weaken Escobedo to the point of saying that a man could be interrogated if he didn't have a lawyer, but he said that he wanted a lawyer and he could not raise one at the particular time, either because of lack of money or couldn't get him on the telephone.
And then I think he could very well say, well, I'm not going to talk.
Yes.
Then if it appears to the trial judge that he really meant he wasn't going to talk, and then after that he was cajoled over, or in Escobedo he was handcuffed or something, then I think the statement would be in trouble.
You say that he indicated he wanted a lawyer when he was forthcoming on.
Yes.
All practically purposes, the interrogation is over.
Well, for the purpose where, to my mind, once he says any terms, I'll talk if.
Well, no, he just, they read him that
Yes.
statement there, and he says, well, I want a lawyer.
Yes.
And the agent says, well, go ahead, get it. Well, I don't have one. The agent says, sorry, we can't furnish you one. He ought to fold up his papers. As I understand you, the agent ought to fold up his papers and leave.
No, sir. I went the other step. I said...
Because the fellow has already said he wanted a lawyer.
Yes, I said that...
Which means he doesn't want to talk unless he has a lawyer.
If he makes that clear, that's it. If he makes that clear.
That's right.
If he makes it clear.
Well, he says, all he says in answer to that warning is, I want a lawyer.
And he says, what I was trying to
And
get
if
over...
he doesn't get one, why isn't the conversation over?
Well, I think that I'm giving him, I'm the agent, I'm giving him another factor, which is that you assume I can get a lawyer for you. And the truth is, I don't have a lawyer, I don't have the money, I can't get a lawyer for you. Now, with that understanding, let me read the balance of this statement to you again. Do you still want to talk? And the guy says, no. Then I say, the agent's through. The agent's through. But I have to, I think in my own mind, I have to have that other one to make sure about it. The real problem is that when he talks later.
But if he says, you read him that part again, and he says, well, what do you want to know? I'll answer some questions, try to straighten some things out. You wouldn't at that point say that there's anything wrong with further questioning.
I think that
You wouldn't insist that they sign a waiver of some kind. You don't think there's anything to waive anyway.
I don't think he has to sign a waiver at all. I think that I don't know if you notice the real careful trial judges. They always at each stage after recess they put these facts in the record. Well, I don't think that's necessary. If you recess the question for 15 minutes and come back, you have to read him his statement over and over again. I think the whole thing has to be taken into consideration.
General, is the warning that was given by the FBI agents in this case the standard FBI warning?
I think so, Mr. Justice Fortas. I have the manual, but I don't have it with me because it's not supposed to be out. I will check it, sir, and if I may send a letter.
I should very much appreciate...
I think it is.
...knowing that, and I should also very much appreciate knowing whether there is any source available to us as to FBI practices.
Yes, sir, it is.
It's been my understanding that the FBI does have a standard practice as to warning and what happens in one event or the other.
They have an official manual. I have it, as I know it could be released to the court, but the question is I'd feel obliged to give it to Petitioner's counsel, and I would much rather check with Mr. Hoover before I do.
Well, I'm not suggesting any particular way.
It's a whole,
I might even
full
say
manual.
whether it's possible, but if, for example, I could know authoritatively
Yes.
just what the FBI warning is, number one. Number two, when the FBI warning is given, at what stage. Number three, what happens in the event that counsel is requested or counsel appears representing the arrested person. Number four, what happens in the event that counsel is requested but that the person in custody does not have counsel.
All right, sir.
I'd be very grateful if there's some way in which...
We'll get that. We'll get that. I hasten to point out, though, that I think the FBI is the only one that does it uniformly. The Narcotics Bureau and Customs, I don't think it's just the FBI.
I know that. That's very evident from the records that we have, that
Yes.
the FBI does seem to have some regularized procedure.
Could I ask you a question on a little broader basis? As I read your brief, the government's position is that as a matter of constitutional right, neither a warning of counsel nor a warning of a right to remain silent is a requirement. But that absent either one of those warnings, those are factors that can be taken into account on judging voluntariness, and that the ultimate constitutional issue in these cases is whether or not the admission or statement or confession was voluntary.
That's our exact position.
Now, you're not receding from that in anything
Not in
you've
the
said.
least. Not in the least. We also say that for practical matter, the warning is better to be given, but it's not required. I have not receded at all.
I didn't understand you had.
No, sir.
Mr. Fawcett?
Mr. Chief Justice, just a few words. I left San Francisco on Friday, therefore, if the page proofs mailed to me Wednesday did not arrive in time, it certainly is not the Solicitor General's fault. The printed brief mailed Thursday did not arrive at that time either. However, I do think it is a little odd that an ex parte request was made for this additional material on January 14th of this year without notifying me. I think it is also curious that I asked for the exhibits when I was first assigned this case in December of '63 and could not get them. Now suddenly they're here. I would also now, on the merits, make a few comments on what the Solicitor General has said. First, saying that the record has absolutely nothing in it. Then he turns around and he concocts this wild story that the petitioner decided to trade a federal conviction or a state conviction for a federal one. He points to the fact the trial judge in California so commented sometime thereafter. A number of interesting points. First, of course, the state charges would have been Missouri, not California. Secondly, he is presently serving a sentence of 30 years with, under federal law, a minimum parole of 20 years. Under the maximum of the statutes he was convicted under, it would have been a 50-year sentence with earliest parole permissible in slightly less than 34 years. As this court, I think, knows, California, at least, customarily pardons life sentences at about 7 to 9 years. The sentence under California law would have been 5 years to life, not just life, as the Solicitor General's brief points out. If indeed Westover made this choice to trade one for the other at the time he was in custody, I submit that shows pretty adequately that he certainly needed counsel. He made a lousy choice. Secondly, on the Coppola point and the detention, we of course are not arguing here, nor did we below, but the Court of Appeals adopted this same view that there's nothing illegal about state-federal cooperation. Of course not. There is, however, something illegal, and I would submit perhaps unconstitutional, about an unarraigned, unadvised detention. It then becomes a question of looking to see how the federal authorities contributed to that. Whether or not Missouri has a small book, 20-hour statute permitting state authorities to hold without a specific charge, I don't think we want to encourage that in federal law. This court need not reach constitutional proportions to strike it down. I'd like to quote, just because I think it's sound, from what the Second Circuit said in the Coppola decision. It said, if this cooperation between federal and state authorities reached the point of arrest and detention by local police for the purpose of enabling federal officers, now, not the only purpose perhaps, but the purpose, to question the defendants concerning the bank robberies for a period of time forbidden to federal officers by Rule 5A of the Federal Rules of Criminal Procedure, admissions thus obtained would properly be excluded. Such a rule prevents federal officers from evading the letter and the spirit of Rule 5A. I'd add just a few words to Mr. Justice Fortas's colloquy with the Solicitor General on the right to counsel. I find it very odd that the standard warning that the Federal Bureau of Investigation gives to counsel, gives to accused, is that they have a right to counsel, yet the Solicitor General stands up here and says, oh, but they don't have a right. I can't understand whether the federal government is talking out of both sides of its mouth at the same time. Are these simply empty words which in fact mean nothing? Finally, I would like to comment on the discussion that has concerned whether or not a person without means to provide a lawyer can say or will say, I won't talk, or I want a lawyer before I talk. I submit first it's pretty hard for a person in detention to stand up to the police, certainly hard for anybody except an experienced criminal. That aside, however, if that is to be meaningful, the common federal practice, which this case has, won't assure it. That is to say, unless you have something like a tape recording of what went on, a verbatim statement of the questions and answers, it is a hollow thing to say, and ever thereafter to know whether or not the right to counsel and the right to remain silent was ever intelligently waived. Certainly a narrative statement such as this, where the federal officer ingests what was said and puts it down in the words, oh, by the way, I would also like to say that, that certainly simply shows no signs of a waiver or much of anything else. Yes, Your Honor.
What do you say to this proposition? This court has go slow on new constitutional rules with these very wide-sweeping investigations of depth now as to what reform will do.
Yes, Mr. Justice Harlan. A couple of points. I'd comment twice, or two ways. First, I'd point out the prompt arraignment statutes on the books of well over half of the states of the Union, and point out that, as this court knows, they are commonly ignored. I think the states have had their time to start to clean this up, and they haven't taken it. I would comment, secondly, that I think the approach of the American Civil Liberties Union is very sound. They say, you needn't say, a right to counsel is ipso facto and barring all else the only way we can protect the privilege against self-incrimination. What they do say is, with what we have now, that's the only way we can protect that privilege. That leaves you open later. If the state comes up with something else, something better, perhaps the tape recording would do it, then at that point you would say that is an acceptable alternative.
Mr. Fawcett, do you agree that, not with me, but with the statement that somebody else here has made, that the issue here should be considered to be Fifth Amendment, not the right to counsel?
Well, as I interpret Escobedo, and as I think it makes sense, I don't really find myself in thorough agreement with anybody else. The American Civil Liberties Union, for example, puts the right very heavily on the Fifth Amendment privilege. But as I said in my argument in chief, I think what Escobedo did was to devise a means to protect that. I think, as has already been said, they are both, and they're part and parcel. But I think Escobedo went more than Malloy versus Hogan. It went to the position of saying, here's a cure, not here's a wrong that must be righted, but here's a wrong that must be righted that may be righted by this means.
What about a third approach, either the Sixth Amendment or Fifth Amendment to self-incrimination?
I wouldn't be troubled by that.
You wouldn't be troubled?
No.
Wouldn't be troubled by what, would you?
By putting the footing on due process. I think probably all of these other rights ultimately come down to due process in any case.
That would lead us to deciding all these cases on the totality of the situation.
No. As I say, Mr. Chief Justice, I reject the totality of the circumstances, and I think Escobedo rejected them. I think it said you must have counsel at this focused interrogation point. Whether you say the reason we must have counsel is due process or that specific provision in the Sixth Amendment, I think is not that important. Yes, sir.
You don't mean to suggest that there's anything short of Escobedo that suggests a different history in this court and this problem.
I think there's a different history, which, starting with the concurrence in Spano, has, as I say, moved away from a necessity of viewing every case on the totality of its circumstances, a recognition that when there's a behind-doors interrogation, you can't always know what the circumstances are, that Escobedo, flowing on Spano, White, Messiah, has gone a step towards rejecting, or at least adding a new qualification to the conventional totality of circumstances.
But Spano itself...
No, Spano did not. It was the concurrence.
Did go on those lines.
Yes, sir. That's correct. That, I think, was the start. It was not, of course, the majority view.
Well, I think if you look in the note, Chambers against Florida,
Sir.
you will find where it was pointed out that there had been two lines, one which used due process in its abstract sense, and one which applied it to the Fifth Amendment and to the precise language of the statute. And I think there were plenty of cases cited along that line.
I think there were. Thank you.